Hello to everyone who is watching this presentation. My name is Jaira Davis. I am an attorney at the Earl Carl Institute located at Texas Southern University, and I am so excited to be presenting this training on transfer on death deeds, basically the when, the where, and the how. I believe in transfer on death deeds so much that I ensured that my own family had them. I truly believe that these are a great tool to ensure that we are keeping property in families, we are keeping homes in families, and it's just something that I truly believe in. And I'm so glad that we are talking about this today. So I'm completing this training for those who want to complete a transfer on death deed, maybe on their own. They want to figure out how to do it, and they came to the right place, the Earl Carl Institute, to watch this video. I also am making this video for maybe legal assistants, paralegals, young attorneys, just legal professionals who want to learn how to do this for their clients. And I will be sharing my contact information at the end. So please feel free to contact me if you have any other questions beyond what we talk about in this training. So let's first start out with what is a transfer on death deed. So the simple way to explain a transfer on death deed, this is a deed that will allow the current owner to choose a beneficiary to receive the property after they pass away. Okay, I want to explain that one more time. This allows a current owner to choose a beneficiary to receive the property after they pass away. The best part about a transfer on death deed, I think the part that everyone truly enjoys, is that you do not have to take the home through the probate process. Okay, that is the thing that really pulls this apart from most other estate planning tools, is that you do not have to go through the probate process to transfer the home if your transfer on death deed is completed and completed correctly. Okay. The next thing I want to note is that if there is no will and no transfer on death deed, the real property must go through the probate court, and the property will pass according to Texas law. Okay, so I want to note that there's no will, no transfer on death deed, or any other estate planning tool that does this type of thing. The property is going to go through the probate process. Something else that is important to note about transfer on death deeds is that this property will pass to a beneficiary regardless of the quality of the relationship between the deceased and the beneficiary. Okay, so regardless of the relationship, I want to give you an example here, right? If there is a blended family and there were children outside of that current relationship, they can still be beneficiaries of that spouse's portion of the estate. Okay, it does not just have to be children that are from the marriage, it can be children that are outside of the marriage, outside of that relationship. So again, you can pass this to a beneficiary regardless of the quality of the relationship. And I think that's what also makes this really nice and really unique. Okay. Um, Again, with a transfer on death deed, probate can be avoided, and decisions can be made in advance on who should inherit a real property interest. And I also want to note that this is effective once recorded with the county clerk and before the death of the grantor. Okay, so you do have to record this with the county clerk, and it does have to be before the death of the grantor or the original owner. Okay. So let's talk about the difference between a transfer on death deed and a life estate deed. I think it's really, really important to discuss the differences here, because this kind of will determine, okay, what is best for my client or me in this situation, with my assets, with all the things that I have going on. Okay. So with a life estate deed, life estate deeds are governed by common law. Okay. A transfer on death deed is going to be statutory. This is going to be governed by Chapter 114 of the Texas Estates Code. So this is something you can go Google right now. Okay. With a life estate deed, you cannot include alternate beneficiaries. You just can't do it. However, with a transfer on death deed, you can include alternate beneficiaries who will inherit the property if your primary beneficiary dies before or at the same time as the original owner. So let me repeat that part. So with a life estate deed, you cannot include alternate beneficiaries, but with a transfer on death deed, you can. Okay. With a life estate deed, this may trigger a due on sale clause when the owner dies. What a due on sale clause is and means is that the mortgage will speed up and everything left on the mortgage may be due when the owner dies. Okay. And for instance, if that's $25,000, most people don't have $25,000 laying around, especially when they have just maybe taken care of a celebration of life ceremony for their loved ones or something like that, right? So sometimes with a life estate deed, once the owner dies, the due on sale clause is triggered regarding the mortgage. And with a transfer on death deed, this does not trigger a due on sale clause. So this is not going to speed up the process. This is not going to ensure that you have to pay, thousands of dollars out of pocket. That's not what a transfer on death deed is going to do. With a life estate deed, this may be created by a person who has power of attorney over the owner, as long as that power of attorney authorizes this type of transaction. Okay. That's a really important note because a transfer on death deed does not allow that. With a transfer on death deed, you can only the owner, a competent owner over the age of 18 of sound mind, can create a transfer on death deed. This cannot be created through a power of attorney. Okay. So that is a really stark difference as well. So again, a life estate deed can be created by a person who has power of attorney as long as that power of attorney authorizes this type of transaction. A transfer on death deed can only be created by the owner who is of sound mind and who is competent to make this type of decision. Okay. With a life estate deed, this can be drafted as a general warranty deed, a special warranty deed, or a deed with no warranty. And that's a really interesting difference as well, because with a transfer on death deed, this cannot come with a warranty of title. And everything I'm talking about with these transfer on death deeds is in section 114 or in chapter 114 of the Texas Estates Code. And finally, for this slide, a life estate deed may be difficult to sell. It may make it difficult to sell the property without the beneficiary's approval. It is going to be difficult to sell the property without the beneficiary's approval. And with a transfer on death deed for 2 years after the owner's death, the property is subject to estate creditors' claims. And so it may be more difficult to sell during that time period. Okay. And the estate creditor claims is only if the estate cannot pay those debts. So those are some of the really stark differences between, a life estate deed and a transfer on death deed. And this is kind of where you're going to want to look at, okay, what are my client's circumstances? What are my circumstances? And what makes the most sense for me to do? This is where you're going to kind of look at that. So why a transfer on death deed? We've discussed what a transfer on death deed is. We've discussed the difference between a transfer on death deed and a life estate deed. But now we want to discuss why a transfer on death deed. Why is this so important? Why should I get this done? So I want to start out with one of the most compelling arguments, right? And this is that the average cost of filing a transfer on death deed with the county clerk is about $34, $34. Okay. That's probably a meal or two at Chili's versus an average probate cost of $1,200 to $5,000. I also want to note that we know that probate costs can cost a lot more than that. Probate can cost a lot more than that because it really depends on the complexity of the estate. The complexity of the estate. So I'm talking an average filing fee of $34 versus anywhere from $1,200 and up. Because again, we're talking about when we get into those really complex estates or those really serious fights, we know that it's going to cost more than $5,000. And that is one of the biggest differences we're looking at when we talk about a transfer on death deed. Okay. So in Texas, you're required to have an attorney when you are beginning a probate, even if all that's left in the estate is a home. Okay, so you do so that $1,200 to $5,000 at least, that is going to be paid. That's not a, it's not, and if it's really a win if you don't get something like a transfer on death deed done. Again, we just talked about the cost of probate ranging from 1,200 to 5,000, but we understand that that can be higher. And the average cost of a transfer on death deed being $34. Okay. Another reason why a transfer on death deed is is a really fantastic tool is because it will exclude property from Medicaid, from the Medicaid Estate Recovery Program. Okay. MERP, or the Medicaid Estate Recovery Program, is a program that will allow Medicaid to recover costs from the recipient's estate after they pass away. The simple way of saying this is that Medicaid will reach back into your estate and take the money that they used to help you when you were sick, right? And they're going to recover their costs there. But having a transfer on death deed can stop this from happening, okay? And so if the client has received qualifying Medicaid services, a transfer on death deed may be beneficial in protecting your home and your property interests after death. And this is really important for your beneficiaries, right? Because again, most people don't have thousands of dollars to shell out to protect the home. And so where Medicaid is coming from, they're taking the home or you have the money. And the final, and again, another really compelling reason why a transfer on death deed is so effective and so amazing is because the owner retains full ownership rights during their lifetime. So you can do all the things that you would have normally done with a transfer on death deed, with an effective transfer on death deed filed and recorded, because it's not effective until after the owner or the grantor has passed. So it's recorded. But what I mean is that, your beneficiary has no rights until you pass away. Your beneficiary cannot control the property at all until you pass away. And so that's why doing a transfer on death deed is protecting your beneficiaries for the future and not taking away anything from the original owner or you right now. So let's look at, so again, we've now talked about kind of what a transfer on death deed is. We've compared life estates and life estate deeds and transfer on death deeds. And we've talked about why a transfer on death deed is so effective. And that's, because you get to maintain, the original owner gets to maintain ownership interests. It protects the home from, Medicaid reaching back and getting that money from the estate. It is so much cheaper than probate. So now that we've decided that a transfer on death deed is best for us or our clients, how do we create one? What does this look like? Let's talk through it, okay? So some of the information that is going to be needed for a transfer on death deed is the full legal name as shown on the state ID of the owner or owners, okay? This is not the time to try to misspell someone's name or try to misspell your own name or insert your, your nickname. This needs to be the name that is on your driver's license or your state ID, okay? The full legal name. Next, you need the full names and addresses of each beneficiary and alternate beneficiary, okay? So again, full legal names, what would be on their ID, okay? And also their full addresses. You need to get this information correct. This is really, really important. So it has to be correct. The next thing I'll say is you need the street address of the real property, okay? So the street address of the real property is what you're going to see on the mail, okay? Or what even is on the driver's license, or what is very commonly used on an application. Versus the other thing we need, which is the legal description of the property, okay? And this is going to be very different than the street address of the property, and I'm going to show you how to find this, but we need the full legal name of the owners, the full legal names and addresses of each beneficiary or beneficiaries, the street address of the real property, and the legal description of the real property. Okay, we're going to need those things. So the most difficult part about this every single time is how to locate the legal description. Where do I find this? What does this look like? Explain it to me quickly. So step one, we are going to find the property subdivision on your appraisal district website. Okay, so in Harris County, you're going to go to hcad.org, which is Harris County Appraisal District, and you're going to search for the property to find its subdivision. So we have a nice little screenshot here, which is going to kind of show you what that would look like here. It's going to be typically 2 lines. Okay. This is not, however, the legal description. So we cannot stop here. We cannot stop here. This is not the legal description. We're going to need to go extra steps to find the deed to find the legal description. So step 2, we are going to locate the real property records of the county clerk's office where the property is located. So let's go back. If you live in Harris County, so for instance, Houston, Harris County, you're going to go to this first website, okay? If you or your client lives in Fort Bend County, you're going to go to this website. So you're going to go to search records on the county clerk's website. And so we have that highlighted here, search records. If you do not have an account, you may need to create one, which is why we have this, the new login, new user, forgot password. So you may need to create one. If not, you're still going to log in. Okay. And this is where you're going to select real property. So you would go down here and you would find real property. You're going to select real property. And then something like this should pop up. And you are going to be able to type in the owner's name in the grantee box and press search. Okay, you're going to type in the owner's name in the grantee box and press search. This is where we are going to get just one step closer to finding the legal description. Okay, so the next thing you're going to do after you've gone to the county clerk's website, you've either created an account or logged into your account, gone to real property records, typed in the grantee's name in the search box. You are going to locate the owner's name. Okay, so let me give you an example. This would be the grantee's name. Okay. You're going to look at the names. Okay. You're going to find an entry listed as WD or deed. So this stands for warranty deed or deed. Okay. It's going to say something along those lines. And you're going to click the record underlined in blue, because that's how you can tell it's the document. So WD warranty deed, or it just says deed. And then you're going to find the document underlined in blue. And this is where you're actually going to click and you're going to be able to see the actual deed, which I will show you on the next slide. So this is a general warranty deed. This is kind of a piece of one. This is what it would look like, okay? You are going to be able to very easily find the legal description because it is most of the time going to be indented under the main paragraphs, right? And it is going to most of the time be either in italics or in bold, but either way, you are going to look for something that is about 4 or 5 lines, okay? On a couple slides back, I showed you a very short description on the HCAD website, which was about 2 lines. That's how you know that is not the full legal description. A full legal description is going to be 4 or 5 lines long. Okay. The next thing I want to say is that you want to be really accurate when you are copying this legal description onto your transfer on death deed. You might even want to have a friend, a neighbor, your spouse or partner, someone look at this to ensure that it is correct, because this is also another big portion of ensuring that there's no issues with your transfer on death deed at the next juncture, right? So this needs to be correct, and you need to ensure that it is this legal description. Again, 4 or 5 lines long. It typically is going to start with lot, whatever, block, whatever, to have the county, state. It might include something about volume, paper, deed records of what county. So that is how you know it is the full legal description. And that needs to be, without the shadow of a doubt, correct. So we have all of the information. We know that we wanted to a transfer on death deed. We have a legal description, which again is the hardest part for most folks. So how are we going to draft this thing? What are we going to look at now? The part is that the eFile Texas website, where we file court documents, has this ready for us. And that is really fabulous. So you're going to go to eFile Texas, which is this link here. Okay. And this page, this is where you're going to land. You are going to click start a filing, and you're going to get to see a list of cases, right? You're going to look for transfer on death deed. That's what we're completing. You're going to look for transfer on death deed. You will click through a number of introductory screens, probably about 5 of them, and then you will be prompted to enter the information that we talked about prior, right? Your client's name and address, the co-owner's name, if applicable, if there's a co-owner, legal description of the property, which is the 4 or 5 lines that we just looked at, right, on the clerk's website in the deed, the address of the property, and that's what you would see on the mail or on their driver's license, and then the information about the beneficiaries. And because we are so detail oriented, we have all of that information correct. Okay. Once this information is complete, you'll be asked to complete a survey. You can skip the survey, you can do the survey. That's, neither here nor there. You are then going to proceed to the next page to view or download the document for your client or for yourself, and you'll select that option where it says actions, okay? Because you would have already reviewed it, so you'll select actions and you'll select, whatever option is best for you. And so the final steps to drafting your transfer on death deed, you have all the information correct, you've drafted it. This document must be signed before a notary, okay? This needs to be executed and signed before a notary. And if the property is owned by more than one person, all of the owners must sign before a notary, okay? It can't just be one person and the other person signs later. Everything has to be signed before a notary. I also want to note that we can prepare a transfer on death deed for a property that you're only the partial owner of. And so what I mean is that if there's 2 people that own the property, we talked about this earlier, but if there's 2 people that own the property and you want to transfer your portion to someone, you can do that. It would only be your portion. So if there's 2 people that own it, person 1 can transfer their 50% to someone through their transfer on death deed, but it would only be their 50%. After the form is notarized and signed by all property owners, we then must take it down to the county clerk's office where we are going to pay that nifty $34, and they are going to record it for us. So when you go to the county clerk's office, you pretty much have to take the original form, the original document, and a copy of the form. Be sure not to take the instructions, that's just extra. So take the original and a copy. You want to take personal identification. You want to take your form of payment. So many of the offices do not accept checks anymore. So I would call to see if they take, cash, card, whatever is best, but your form of payment, which is your $34 roundabout. And then you want to file the original, and you want to request a copy for the owner's records or your own records. Okay. You always want to do that. So file the original and always ask for an additional copy. And then you want to keep that deed in a safe place. And what I mean is, a fire safe lockbox, or at the bank, or wherever it's going to be. And then you need to tell the beneficiaries or the co-owners or whoever you need, or whoever needs to know where this is, you also need to tell them where that is. Okay. And so if you or your client are unable to file it, contact the county clerk's office to see if there's a procedure for that situation. Most of the time there is. Okay. These county clerk's offices deal with a lot of different scenarios, and they are really great at their job. So always call them if you have questions about any of your documents. Okay. So we filed it. We decided that this was the best option for ourselves or our clients. We went through the process. We found the legal description. We drafted it. We filed it. What happens now? Well, the best part about this for the grantor is that they will continue to have full ownership rights until their death. They can sell it, they can take out loans, and they can maintain their tax exemptions. That's the best part about this. After the grantor dies, the beneficiary should file an affidavit of death in the county records. And that's kind of what is going to happen from there. So after the grantor dies, the beneficiary will file an affidavit of death in the county records. and the title will not pass until this affidavit is filed. So this affidavit is what is necessary to transfer title. So changing or canceling a transfer on death deed. Change or cancel a transfer on death deed in a couple of ways, right? So one of the ways you're going to do this is you can record a new transfer on death deed with a different beneficiary. So that's one. Two, you can record a cancellation of the transfer on death deed. You can always do something like that. Or three, divorce. And so if you plan on this option, your transfer on death deed, the divorce decree will invalidate your spouse if they are listed as a beneficiary on the transfer on death deed. So that's kind of what happens there. The divorce decree will invalidate your spouse if they're listed as the beneficiary. So let's go through frequently asked questions. Okay, let's go through some frequently asked questions. Does a transfer on death deed replace a will? So the answer here is no. They can coexist. They can be around at the same time. A will is still important for transferring personal property and other items not covered by the transfer on death deed, but they can coexist. What happens when my beneficiary in the will is different from the beneficiary in my transfer on death deed? The transfer on death deed is always going to supersede the will, okay? So if we're talking about which one, if the will or the transfer on death deed is going to win, the transfer on death deed is going to win every time, okay? The transfer on death deed is going to control who owns the property, whether the will was created before or after it. The transfer on death deed is always going to supersede a will. Do I need a transfer on death deed if I have a will? So I would say so, yes. You can, because you can use a transfer on death deed to transfer the property outside of probate, okay? A will can still be effective for transferring property, but a transfer on death deed is going to allow that transfer without the cost of probate, and that's why it's so important. Frequently asked questions for beneficiaries. Can I name more than one beneficiary? Yes, you can name more than one beneficiary, and an alternate beneficiary can also be named if the first beneficiary passes before the grantor or at the same time. And that leads me nicely to my next frequently asked question. What happens if the beneficiary dies before the grantor? So for the purposes of a transfer on death deed, the beneficiary must outlive the grantor by 5 days for the transfer to be effective. So if there is no beneficiary, they do not, live past the grantor for 5 days, or they pass before the grantor, there's no alternate, the transfer on death deed is not valid, and the home must be placed into the probate process. Okay. So that's why having alternates is really important on these types of things. The next thing I want to say about this is that the grantor can specify on the transfer on death deed if they want the property to go to the beneficiary's children or other named beneficiaries should the beneficiary pass before the grantor. So you can specify how you want it passed if something happens to your beneficiary or beneficiaries. Okay. Must the beneficiary be a person? No. The beneficiary can be a person, organization, institution, charity, trust, etc. However, the beneficiary must be specifically named. So it can't be a class of persons or a group. They cannot be named. It needs to be, a specifically named, person, organization, institution, charity, trust, etc. Okay. Does the beneficiary need to sign the transfer on death deed? No, they do not need to sign or receive the record. However, you do need to tell them that you are listing them on this transfer on death deed. Regarding any of your estate planning documents, your beneficiaries or your appointees need to know that you have listed them as a beneficiary or appointee. That is how it's effective, okay? So frequently asked questions regarding co-owners. What if I own the property with someone else? So we just discussed this. Only your portion, your interest, can you transfer through a transfer on death deed, okay? I own the property with my spouse. Since Texas is a community property state, I don't need a transfer on death deed, right? Well, Though Texas is a transfer on death deed, you would still need some sort of document to assist you with completing that chain of title. And so you might need an affidavit of heirship or something different. But the problem with an affidavit of heirship is that it can be challenged. A transfer on death deed would eliminate the need for any additional affidavits or any additional links in that chain of title. Okay, so that's why still having a chain of title or still having a transfer on death deed is so important. I own the property with my spouse and hold power of attorney for their financial affairs. Can I execute a transfer on death deed for both of us? No. As discussed earlier, a power of attorney cannot be used to execute a transfer on death deed. The person executing a transfer on death deed must be competent and sign it themselves. Does a joint tenancy with rights or survivorship do the same thing? No. In a joint tenancy with rights or survivorship, the property interest passes to the surviving joint owners. Under a transfer on death deed, you are only passing your interest to the beneficiary of your choosing. Okay, so that's the difference. That's the biggest difference. With joint tenancy with rights or survivorship, your property interest passes to the surviving owner. So it passes to this person. With a transfer on death deed, your interest passes to whoever you choose. It does not have to be the joint owners. Okay. Frequently asked questions regarding creditors. Can I file a transfer on death deed even if I haven't paid off the mortgage? Yes. If you have not finished paying off the loan by the time the grantor has passed, the beneficiary will be responsible for paying the mortgage, right? The beneficiary of the home will take the home, will have title to the home just as the original owner did, so that if there's still a mortgage, they'll still have to pay the mortgage. And this is nicely leading to the next question. Does a transfer on death deed shield the property from creditors? No, just like it wouldn't for the original owner. And then finally, are there any tax consequences for a transfer on death deed? And there should not be any federal or state estate tax consequences for a transfer on death deed. There should not be any. Okay. So I truly hope that this was helpful to you. I hope that you see why transfer on death deeds are so effective and so helpful and so amazing. I do want to make a last note that transfer on death deeds are not available in every state. So you just have to be careful, and you really do have to contact other states and their attorneys to kind of see where that information is. But this is my contact information. Please feel free to contact us if you ever have any questions about transfer on death deeds, or if the Earl Carl Institute can help you or a family member with any legal matters. It has been my pleasure to present this information to you today, and I thank you so much, and I hope you have a great rest of your day. Bye-bye.